She walked into court convinced one body camera video would destroy the prosecution's entire case. But before she could finish explaining, the judge asked one question that changed everything. Watch what happened next.
Ma'am, you can go right. John, why don't you get those files off of there? So I'm going to have her sit there. You can have a seat right there, okay? Or you can argue with the podium if you want to. Either way is fine.
Okay, I'll stand right here.
Okay.
I did have a copy of that motion for you.
I've read them. Your name?
Shannon Phillips.
And your name?
Caitlin fully hired in Jasper Township.
Okay, you can go ahead and proceed with your motion, Ms. Phillips.
So, good morning, Your Honor. Shannon Phillips on my own behalf. I am here on the motion to dismiss.
And you still don't want a lawyer?
No, sir.
Okay. Because you know I'll give you one, right? I just want to cover that.
Yeah, that's my right.
Okay.
And it's also my right to represent myself.
You can represent yourself. I don't have a problem with that. Go ahead.
Okay, I am here on my motion to dismiss both counts of hinder and obstruct a public servant. I am asking the court to dismiss these charges with prejudice because the officer's own body camera proves he was biased.
Do you have the body cam?
Yes, sir. I did bring the USB with Officer McParland's body camera.
Have you seen that, Ms. Foley Carter?
Very different interpretations of the body cam.
Okay. Well, I would like to see the body cam footage. So Heather, can I send her down there and you guys can get her set up where we can put it on the screen?
I don't think we can do it through here. I think it has to be set up through there. Let me check with Shane.
Okay.
Yeah.
She has it on USB. Is that what she said?
How lengthy is it?
It's 25 minutes. I didn't want to edit it or make any edits, but it is 25 minutes about.
Jeez.
I did create timestamps of the necessary, him telling me to get out and then trapping me, not letting me leave, never telling me I was under arrest, him apologizing to the sergeant, saying,
Thank you.
I had to go hands on her. I'm sorry, Sarge, I had to do that. She's claiming I pushed through the officer. My hands were up the whole time. And yes, I walked to the door.
Okay, so let me ask you a question.
Yes.
Well, why isn't this a fact question? Why isn't this for the jury to decide or me if there's a bench trial?
We can go to trial. You don't have to dismiss. We can go straight to trial. I'm okay with that. And I'm ready to move forward.
Okay. So you're going to withdraw your motion to dismiss? Is that what you're going to do?
I mean, if you don't want to watch the video and you dismiss the charges after watching the video, then we can go to trial, sir. I don't want to argue. I don't want to fight.
No one. Hang on. I'm not arguing with you. You take me as arguing with you?
No, I'm just saying, sir. I don't the back and forth. Like I don't want to do it. But again, we can go to trial.
What do you mean? What back and forth? Tell me. I don't want to know what you're saying.
What you're saying? You don't want to take this to trial one time.
I did not say that. When did I say that? I said, why isn't this a fact question? She's looked at the video. She disagrees with you. She's duty bound to dismiss the case if there's no valid charge here. It's based on what's in a body cam. And I'm just asking you, I'm not treating you any different than I would a lawyer. If a lawyer filed this motion, I'd be asking him or her the same questions. Why isn't this a fact question?
I don't know, Your Honor. Could you rephrase the question what you're trying to ask? I feel like it should be dismissed. Because I was never told I was under arrest. They assaulted me and then tried to cover it up. This happened April 29th. She only filed charges on 5/13. I also have another pending charge that she wrote in her response, trying to make it seem like I'm just some criminal, saying, oh, she has fired up stalking charges that we're currently going to trial for now. But those same charges, she wants me to plead to a disorderly person.
Well, you don't have to plead to anything.
Exactly. We're going to try it. So, like I said, I brought the USB if you would like to watch it and whatnot. And yeah, if not, we can go to trial. I believe she won't be able to prove all the elements beyond a reasonable doubt.
And then, so after she puts her proofs on, and after you cross-examine her witnesses, if it's a jury trial, you can make a motion for a directed verdict.
Yes.
And then I have to take all the evidence, just so you know, in a light most favorable to them, and find that that a reasonable fact finder could not find that proof exists beyond a reasonable doubt. That's all I'm trying to tell you nicely here. It's not that I don't want to look at the video. I'd be hard pressed to stop everybody else's court proceeding today so I can look at a video that's 25 minutes. Can you figure out a way to copy that?
Yeah, you don't want to play it now. You just want.
Yeah, because I don't know how I can make everybody wait for 25 minutes.
Your Honor, I can send it to the court, so you don't need to make a copy of it.
Okay.
I mean, or you can have this USB. I made it so before the court.
Well, I don't want to take your evidence from you here and be responsible for it. Here's what I'm going to do. This was an arraignment June 17th. This is July the 29th. Here's what I'm going to do. I'm going to set this for a jury trial, and I'm going to set it for a final pretrial. So we're going to set a jury trial date right now. And then we're going to set a final pretrial date, motion hearing date, the same. We'll do it at the same time. And I'll review the video before you come back for a body cam video before you come back, okay?
Okay, and then just so you know, I have trial with Heston August 6th and 7th.
Judge Heston.
Mm-hmm.
Yes, that's fine. Give me a jury trial date if you would, Heather.
I'm sorry, when did she say she had the jury trial with Judge Heston?
She said August 6th and 7th. We're not setting.
Oh, okay, that's okay. Let me look at our calendar, make sure you don't have anything on this. We have August 21st available. We have August 28th, I believe, available.
Set this. Wait a minute. Let's do this. Let's pick the final pretrial date first, because I'm not going to be here in 2 weeks, right? So
correct. So we could do okay, so our final pretrial we would have to do on the 20th.
August the 20th.
Yeah.
And let's do this later in the morning at 11 a.m.
Okay.
And you send that to me, Ms. Foley Carter. CC her on your email, whoever you're sending it to. I'll review it. Somebody, you need to give me that the day before, 2 days before, Sadie. Okay, can you make a note of that? And then we'll set a jury trial date right now. When can I do that?
Let's see. You have one September 11th already. Do you want to do September 18th?
No. Who's September 11th?
Wendy Augustinus.
It's with me, Your Honor.
What's that kind of case?
It's a disorderly person.
Is that likely to go?
I will know today.
We're going to set this for September the 11th right now at 8:30 in the morning. Proposed jury instructions, Ms. Phillips. Now listen to me very carefully. You think you two can get along and prepare joint jury instructions? Are you going to be cooperative with her, Ms. Phillips?
Yeah, that's fine. I'm always cooperative.
I'm not suggesting you're not. You're fine. Just you don't need to come in with an attitude. I'm going to hear you. And if you deserve to win, you're going to win this case. Okay? If you don't, you're not. Period, plain simple. But I didn't ask you to comment as to whether or not you're cooperative. I'm asking, I know there's some bad blood here. I can tell by the briefs, and I can tell how you've come in here before, in fairness. And I just want to make sure that you think you can get in a, I can either have you do separate proposed jury instructions, or you guys can get together and submit a jury instructions that you both agree to, with the understanding, if you don't agree on an instruction, then I'll hear arguments on that in that regard, and I'll decide whether or not the instruction should be read. Can you get with Ms. Foley Carter?
I'm sure, thank God.
Okay.
We've been talking really well through email, so
Okay, good. All right, now listen to me very carefully. I mean, no disrespect with this. What is your highest level of education?
From college.
These people, they go to law school. They pass the bar exam. Then they work at practicing for years. Like, you wouldn't expect if I got hurt that I would hire you to be my doctor, or if I needed a tooth pulled that I'd hire you to be my dentist. I'm only telling you, you can think about it. You have every right to defend yourself. But but just understand that you are subject to having knowledge of the rules of evidence, the rules that apply in a jury trial. I personally have only seen 1 or 2 people do that very well in my 31 and a half years here that are lay people. Maybe you'll be the best. I don't know. I'm just suggesting to you that you reconsider what I'm telling you, and that you consider allowing me to appoint you a lawyer. You don't want a lawyer? You can run these gamuts all you want. You know, you can run the whole gamut if you want. And I'm just telling you, if the last thing I want to see happen is somebody get convicted that didn't do anything wrong. And that's always subject to a real possibility when they're doing something that they probably aren't equipped to do. You're not equipped to be a lawyer. You have the right. You have the right. Do you understand what I'm saying?
Yes, I understand, Your Honor. I went through the same thing with Hesson.
Judge Hesson. Judge Hesson.
And yeah, I understand she is has a lot of experience. But Your Honor, I'll be okay.
All right. So we're going to put this down for proposed jury instructions due by, I'm going to say, September the 2nd. We're going to have the motion hearing on August 20th at 11, and the jury trial September 11 at 8:30. Okay. And that's it. Is there anything anybody else would like to bring up?
No.
Ms. Foley Carter? Anything? Okay. All right. Good luck. Go down the hall. We'll give you your notice, man. Thank you. Thank you.
In the end, this hearing wasn't about proving who was right or wrong. It was about understanding how the courtroom works. The defendant believed the body camera footage would immediately clear her name and insisted on representing herself. But the judge explained that courtroom decisions aren't based on confidence alone. They depend on evidence, legal procedure, and what can actually be proven at trial. Even after being warned about the risks of going without a lawyer, she chose to move forward on her own. Rather than dismissing the case, the judge scheduled a trial, where every claim and every piece of evidence would finally be tested in court. This hearing is a reminder that believing you're right isn't enough. In court, the strongest argument is the one supported by evidence, preparation, and the law. The real outcome of this case would be decided at trial, not during this hearing.